Welcome to the Ohio Eviction Playbook.
Hey everyone, welcome back to an all-new episode of the Ohio Eviction Playbook with attorney Ed Kasputis. I am your host, Mike Leon. You know, Ed here is a longtime attorney in the state of Ohio, former state legislator, and the founder of Kasputis Law. He approaches the evictions through both a legal and business lens. He's been helping landlords and investors avoid costly mistakes along the way. Today's episode, we're going to be covering the common legal defenses that can defeat an eviction action in the state of Ohio. Ed, it's good to see you as always. So let's begin with something that you can kind of explain to the audience. That's deficient content or service of a notice to vacate. Like, what is that? And what makes proper service of an RC 1923.04?
All right. Thank you very much, Mike. Thank you for having me on. That's a formal way of calling a 3-day notice. I'm asking you to leave. And whether a landlord comes to me, or let's pretend I'm a defense counsel, the first thing I'm ever going to look at in an eviction is show me the 3-day notice. Is there any technicalities wrong with it? Because if there is, case law says the court doesn't have the power to hear it. So let's say I'm representing a defendant and the 3-day has the wrong date, the wrong address, a reason that's not legitimate. You know, I've had people call me up saying, I want to evict this guy. He always pays late. And I go, did you accept his rent this month? Yeah, but he always pays late. That is not a legal reason to evict someone if they pay late, only if they don't pay. Then there's the statutory language. You got to look at that. So I hate to say it, but when landlords come to me with their own 3-day, 50% of the time, I have to draft one for them because there's some kind of technical defect that will drive them crazy if 3-4 weeks later we're in court and we lose on that technical defect.
Ed, let me ask you about staying on that 3-day or the notice period, et cetera. So let's say someone doesn't comply with that. What are some of the jurisdictional consequences for the trial court and any eviction judgment, that will be entered?
They dismiss the case. And let's pretend you have a judge who is not good and he grants an eviction. Then someone goes to a good attorney and they go, wow, look, the 3 days defective. I can file a motion to vacate the judgment for the following legal reasons because it was a defective 3-day. It doesn't matter that the client or the tenant is 4 months behind. If the thing is defective, you buy more time. And if you're a defense attorney, you just want to keep buying more time for your client, even if they're absolutely going to get evicted, so that they can peacefully and conveniently leave.
Ed, let's turn a little bit to the service of process here for a second. What are some of the procedural requirements for obtaining proper service in an eviction action under Ohio civil rules?
Well, under the civil rules, the clerk of court can serve the complaint via regular mail and certified mail. If the certified is unclaimed and the regular mail doesn't come back, you have good service. Another option that you can have is you can ask for the bailiff to serve. Now, here's a crazy thing that happens among different jurisdictions. For example, in Cleveland, for them, bailiff service is the opposite of the suburbs. In the suburbs, bailiff service means I take the complaint and the summons. I go to the home and I post it on the door. That's residential service. You can do that for an eviction. However, Cleveland, you scratch your head, they don't allow that. Their version of bailiff service is the bailiff knocks on your door, and if you answer the door, they hand you the summons and complaint. You've been served. But if they don't answer the door, they don't serve you. And the bailiff will try that 3 times. Now, in Cleveland, there's times when you have to do bailiff service because you'll get a funky message from the post office. They'll send back the regular mail and say, wrong address. And then you talk to the landlord and goes, that's the right address. I own it. Cleveland won't let you reissue it via regular mail again, even though the post office screwed up. So then you either have to have the bailiff do it for $30 and they'll try 3 times, or you hire a private process server who will literally, if they have to, sit outside the home and wait for the person to either come home from work or leave the house to serve them.
Ed, can I ask you about the waiver part of this on the 3-day notice? Like, if a landlord accepts rent after serving a 3-day notice, How does that affect the court's jurisdiction over the eviction action?
Well, the court's analysis is that when was the 3 days served? They'll take, well, let's say example, February 6th. All right, so the court is focusing. Have you accepted a penny of rent for the month of February? If you've accepted $100 of rent, a penny of rent in February, then it's the equivalent of ripping up the 3-day notice because you accepted a partial payment. Let's say that the guy owed you 5 months of rent and he pays you 3 months in February. Well, then the court's analysis is, all right, that goes to previous months. Still, not a penny has been collected for February rent where you served the 3-day, correct? Yes. Then the eviction can proceed. It's collecting future rent. I took money for the month of February. February's not over. You dummy, you can't evict for February. You got to wait till March. Then you can make the demand. You know how you owe me $500 in February? Yeah. I will not accept a penny of March rent until you pay all of February with March rent. If not, then I'm proceeding with an eviction.
Okay, great explainer there. You've and answered one of the follow-ups I was going to ask you on that. But let me go back a second. If the proper service of process is not obtained, what effect does that kind of have on the eviction judgment or any writ of resolution?
You've never had your eviction hearing. So if you don't get service on the individual, you're kind of like in purgatory waiting for the first inning to begin. And then under the civil rules, they make the assumption that after 6 months, you better have a good reason why you haven't figured out how to serve the person, or we could dismiss. And under the civil rules, after 1 year, I don't care if you have the best excuse in the world, if you don't have service after 1 year, we're dismissing your action. And remember, in the nuclear moment, you can do service by publication. Very rare, but you can pay like $300-$400 and have the complaint put in Cleveland, the Daily Legal News, to say, attention to the world. We're trying to evict Joe Blow from 123 Main Street, and nobody responded. We have service.
Yeah. Joe, I love a good baseball analogy, so I'm following you all the way through on that. Let me ask you, how does the waiver apply? We talked about 3-day, but how does the waiver apply in the context of a 30-day notice, especially when the landlord accepts the rent after the expiration of the notice?
Right. So let's say that my client sends a 30-day notice in January saying, attention tenant, February will be your last month. And then the tenant pays them March rent. Well, the court looks at it and says, you just ripped up your 30-day notice. You forgave him because you cannot accept March rent when you're demanding that February 28th is his last day. But let me give you another crazy idea of waiver. And I always warn my clients, whoever serves a 30-day notice and a 3-day notice, they have to come to court. I've had fact patterns where employee A serves a 30-day and then he gets fired. Then it's time for the hearing. We don't have anyone that can testify that they served the 30-day. So what's the moral of the story? You got to start over. But as a businessman, there comes a time where it's like, I caught employee A stealing, but I want to get rid of tenant B. Well, you knew the guy was stealing. Fire your employee and start the procedure all over again for the legal proceedings, because you've got to protect your business first and worry about court cases second.
You know, Ed, we talked a little bit about in terms of not paying rent, but how does the waiver operate if a landlord serves that notice and it's based on like health or safety violations? And what happens if the tenant remedies that condition before the termination date? Like, how does that work?
All right, under the Ohio Revised Code, you can't do immediate eviction if you determine my tenant is living like crazy, dirty, dirty, dirty. You have to give them a notice saying you have 30 days to clean up your apartment. I will inspect it. And if it doesn't meet my satisfaction, I will start eviction proceedings against you. And one of the key things in that 30-day notice is that you have to say, if you don't correct this remedy, I will evict you. I once had a case where I was representing a defendant, and it didn't have that language that if you don't clean it up, I will evict you. I went to the Willoughby Municipal Court. I stared down the other attorney. We were playing poker. 2 minutes before the hearing, okay, Ed, I'm dismissing. He didn't want to admit that it was wrong, but it was. Now, why do I occasionally do that? Because it makes me a better attorney by looking at both sides of the eviction process, so that's a lesson I will never forget, as 98% of the time when I represent landlords.
I love looking at it from both sides, Ed. That applies in a lot of things in life. Listen, I did want to ask you, how does a tenant's timely surrender of possession? You mentioned a little bit in that example. Like, how does a tenant's timely surrender of possession in response to the 3-day notice, does it operate as a defense to the eviction action?
The eviction, in theory, should not have even been filed. The dream of the legislature, by requiring a 3-day notice, is give these folks 3 days to get out so that there's not even a court case. Now, 98% of the time, people can't get out. They can't get out in 3 days. But from a practical standpoint, let's say you have a hearing in 3 weeks. You go to court the morning of the hearing and you give the keys to the landlord. The landlord has to dismiss the case. They have possession. They don't need the court to help them have possession.
Ed, as we kind of put a bow on this episode, how can a course of conduct between a landlord and a tenant, such as, like repeated acceptance of this late rent that we've been talking about, how can that affect the landlord's ability to evict the tenant for non-payment?
90% of the time, the court looks at the four corners of the lease, but there is an exception, and that's called course of conduct. So you walk into court, your lease says rent is due by the 5th of each month. And then you take testimony of the parties, and it's like, well, I've been paying around the 15th of each month. Well, then the court scratches their head and says, darn it, by the course of the conduct of both parties voluntarily, you have changed the written word of the contract, and we're going to say that rent is now due by the 15th. We're here today. Why, Mr. Landlord? Because he paid his rent late on the 13th this month. But stop. For the past 6 months, you've been accepting it around the 13th, 14th, and 15th. That's true. All right. Under course of conduct, the court finds, take his rent. He's not paying untimely. You have changed the terms of your lease through your conduct. And the way that a landlord has to correct that is they've got to write a letter to the tenant saying, dear tenant, I know for the past 6 months, I've allowed you to pay on the 15th of the month when the lease is for the 5th of the month. But starting 30 days from now, I will no longer accept late rent. You got to pay me by the 5th of the month. And then when you prepare to evict them, you should attach that letter, the course of conduct correction letter, to your complaint to tip the judge off of, oh, they know what they're doing and they've corrected the course of conduct problem that they did through their actions.
Oh. It's great stuff as always, Ed. I appreciate the time, insights, and breaking this all down for the audience. Thank you, sir.
Thank you.
That's it for today's episode of the Ohio Eviction Playbook. If you want to learn more, you want to connect with Ed and his team, do me a favor, visit kasputislaw.com today. And one more favor, as always, before you go, hit like, hit subscribe, leave a review, comment, share the episode with someone in the state of Ohio that needs to hear it. As always, I'm Mike Leon. We'll see everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.